Hi, and welcome to Academic Compliance Academy. In this video, I'm just going to sum up on the latest videos on law and compliance, the introductory part, because there's going to come a lot of more technical videos on certain elements and what we should think about in terms of lawmaking and compliance. So I'm just summing up on the introductory part here. So, to reach full compliance, it is essential that we understand what we're complying to. And to understand what we're complying to, we need to say, okay, if we're looking at the legislation, because the subject is the law and compliance. So if we're looking at the law, what is the origin of the law? We need to understand the decision making that lawmaker, legislator has made to really fully grasp our compliance commitment and the requirements that lawmaker actually wants us to comply with. So, and this is no matter if you're a public or a private entity or even member states, because member states need to do the same exercise towards EU regulation, where they can put in these different angles and reflect on how they are to comply with EU regulatory requirements. So we need to focus here on the process, because if we want to comply with anything, we need to say, okay, what are the steps behind it, so we can try to understand the expectations that are put into the legislative the provisions, the laws that come out there. So we need to understand, because everyone knows that sometimes it can be hard to interpret what the legislator want, what is the actual requirement. And that is kind of the testing we do here. We look at the aim of the document, we look back and try to put ourselves in the legislative mind to really subtract what legislator wants us to do and what is the aim and purpose of the regulation. So as I said, national legislators also have to do this. They need to choose, when they get a directive or a regulation from the EU, they need to choose the correct strategy to implement these measures in national law. Of course, with a regulation like GDPR, it is direct, there's not a lot of interpretation. But if we do have directives, minimum directives, or other types of directives, well, then it doesn't have always to be written specifically word-wise in the national regulation. And sometimes it might even address specific type of companies that's not allowed in your member state. And there you have to figure out how do we address these points. So whenever there's international regulation, national legislators also need to choose the correct strategy. They need to find out how are they going to implement this. Are they going to do it by hard law or soft law? Because if it's principle based, you might just have like that it's not hard law that you're implementing, but it's just the principles. It might be some elements from the preamble that you want to secure through soft law mechanisms. And after that, we need to, as a legislator, you need to say, okay, so if it's hard law, if we're going in and writing it in the text, in the legislation, in the provisions, how are we going to do that? Are we going to do it via rules or standards, or a mix in between? Because how we formulate our legislation really has a large impact on how the recipient, the companies, will act and behave. So there's a lot of thought into this. It's not only private entities that need to apply to law. National legislators have to do the same compliance assessment. They need to make a strategy on how to implement certain international regulation, and they need to assess how they actually want to do it. So, as I've said before, if it's a private or a public entity, it doesn't really matter when we look at the compliance method and what we need to understand, because we need to understand all the thoughts that have been behind the written word in the text. And sometimes I've just put out 2 questions here. If you're in doubt, you're sitting with a provision, with like a specific provision, might even just be a chapter in a law or something, and you're like, oh, so how am I going to comply with this? What is the meaning? Because there might not be a lot of supportive text, white papers or something on the stuff. Then you ask yourself some questions here. So why has the provision been chosen to be presented as hard law and not soft law? Just, it might be obvious, but sometimes trying to articulate the answer for this question might help you in understanding. But of course we couldn't do soft law, because what the government or what our politicians want in this context is blah, 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 blah. And then you get the argumentation of what is actually the intention behind the choice of choosing hard law instead of soft law. Might also just be an obligation. And sometimes, let's just face it, competent authorities, the national legislature, might not always have done the thought the whole way through. But to understand the compliance regime, you need to be able to do this as a private or public entity, no matter what. Second question, why did the legislative power choose to draft the provision as a rule or a standard? So here again, it might be obvious as a capital requirement or something, but still, if you have to argue why is the capital requirement set at this stage, try to argue your way around. And as I put down here in this slide, I said that if you do this exercise, most answers will actually be reflections back to the aim, to the general principles within that legal area. Something that you would find written in a preamble in the EU documents, the EU legislation. So these aims and principles will start being your argumentation when you have to argue what the legislator wants by the choices that they have chosen. In that sense, you're actually creating a baseline of understanding how to reach compliance, because you start using the mind of the legislative power. And then you say, okay, so what they want is this, because the aims plus this type of provision and how they formulated it means that they want us to do this. Then you know then you know how to become compliant. And that is pretty much the point of this whole this whole challenge, is to get your mind in the legislative movement. And there's a lot of other factors that we will go into, but this is just summing up the introductory of law and compliance. So I put this here. So through this short introduction to law and compliance, if you look at the videos, it should be clear now that what you want to know is, just starting point is understanding the regulation. And this is not just like a lawyer saying, oh, you need to understand you actually need to understand the regulation. And the starting point to do so is to understand the general principles. Typically going back to, if you're looking at national legislation, if there's no white paper or anything, go back to the actual EU legislation and look at the preambles, because they will actually come with the political, but also the general legal principles, and explain what the aim of this type of regulation is. That is also the second. So the aim, so start point, where does this come from? Second, the aim and the regulatory interference. Why are they doing this? Why do they want to regulate this area? Well, there might be some market failure, there might be something wrong that hasn't fixed itself, because typically, I know there's political agendas also, but typically we regulate when there are some faults or mistakes or something that is not effective, efficient in society, and then we regulate upon that. Especially when we're talking about the EU, because it's more secure. It has a baseline that is less vulnerable for political standards that might take like huge swings around. So it is kind of more robust. So when you look at the aim and why the interference comes, which will also typically be written in the preamble, you need to look at the choice of the regulatory format, also at the EU level. Is this a minimum directive? What does this tell you? Well, typically, a minimum directive tells you two things. They're setting the lowest standard, but sometimes it's also the easiest way to get something done. As we've seen from different areas within EU law, you kind of start with the lowest denominator, and then you build up. At some point, it becomes a regulation, but it has like a build-up process, which is also based on politics. At last, when you regulatory format, it's also so how did they formulate it? Standards versus rules, hard law, soft law. And then you need to look at the interconnectedness. And that is when you link it together and ask yourself the question. So why did they choose to formulate this as a very clear requirement in a rule in hard law, given the aim and the context of this type of regulation? Understanding that is getting the complete insight and reflections on the regulation, and thereby securing compliance, or at least knowing what is expected of you and what you should bring forth when you're doing your compliance assessment. So this was just a wrap up on law and compliance. So stay tuned, subscribe to the channel, and let's talk more about compliance.